In 1963, I stood with a lot of other people on the National Mall and heard Dr. King's speech in August of that year, I Have a Dream. And this agency was the result of the Civil Rights Act of 1964 that came the next year. And it's very important in our American life. It receives complaints of discrimination and is charged with investigating those complaints to determine whether or not they have merit, and then attempting to resolve them informally through conciliation and mediation. That's the charge. I have two primary concerns with the EEOC. First, I believe the EEOC has placed too much emphasis on litigating high-profile lawsuits and too little emphasis on dealing with the complaints that have been filed, creating a huge backlog of complaints about discrimination. And second, I don't believe that the Commission has been as transparent as it ought to be in terms of the guidance that it should issue about its activities. Let me explain a little about that, and then I'll ask questions more about that. The litigation strategy the EEOC is using today is time-consuming, costly, ought to be the last resort. Last year, more than 93,000 charges of discrimination were filed with the EEOC. About 3,000 of those came from Tennessee. EEOC reports that 70,000 of the 93,000 charges are unresolved and still pending. A backlog of charges pending is nothing new for the EEOC, so why not spend the time and money you're spending on these high-profile lawsuits instead on resolving actual complaints that are filed and are part of the backlog? This desire to win big lawsuits has backfired. Numerous federal courts have criticized the EEOC's litigation practices. I think example of the Kaplan Higher Education Corporation, EEOC brought a case, received a sharp rejection by unanimous three-judge panel in the Sixth Circuit Court of Appeals. The Wall Street Journal named it the opinion of the year. Here's what the court wrote, quote, EEOC brought this case on the basis of a homemade methodology crafted by a witness with no particular expert to craft it, administered by a person with no particular expertise to administer it, tested by no one, and accepted only by the witness itself. That's embarrassing to bring a case like that and have a court unanimously say that. The court also criticized EEOC for bringing a case against Kaplan for using the same type of background check that EEOC itself uses. EEOC has been ordered to pay attorney's fees in 10 different cases. In 6 cases, fees were awarded under a rare provision in Title VII of the Civil Rights Act, which is reserved for cases that are, quote, frivolous, unreasonable, and without foundation, or continue to be litigated after those circumstances became present. That's embarrassing, too. This costs taxpayer money. It hurts the victims of workplace discrimination. I believe the Commission's exercised too little restraint over the General Counsel. I believe the EEOC should immediately reconsider the strong emphasis on lawsuits which are not based on any complaint and do not even have a victim plaintiff. In recent years, the Council's pursued a number of cases without complaints, such as age discrimination against large accounting firms whose partners have voluntarily adopted a mandatory retirement age. It's hard to imagine why you would spend time on that when you have 70,000 backlog of actual cases of discrimination that are unresolved. I'm concerned about the lack of transparency and guidance. What I mean by guidance is whether you allow the public to comment on the proposed guidance on regulations. And finally, and I'll ask a question about this, in the Affordable Care Act, there wasn't much bipartisan about it, but one was to encourage wellness. And we heard testimony in both the Democratic caucus and the Republican caucus from Safeway and other companies that encourage wellness in their companies by saying you'll have cheaper insurance if you lead a healthy lifestyle. The Obama administration had regulations from Treasury, Labor, and HHS that were working just fine until Labor rewrote them and made it more complicated to have wellness plans. And now the EEOC has not yet issued regulations about what its attitude will be, yet it's suing companies who are trying to follow the spirit, I think, of the Affordable Care Act on wellness. So I want to ask about that when my time comes. Thank you, Mr. Chairman.